Does that include members of the district attorney's office?
Oh, you were not here for that discussion. The district attorney's office is not going to be reviewing that. I will review it.
This jury trial was supposed to go forward until surprise evidence surfaced. Now both sides admit they didn't know it existed, and the judge pauses everything to make sure the truth is reviewed before trial continues.
We were scheduled for a jury trial. However, there's been new evidence that there's no way the state would have known or the defense would have known. Is that correct for both parties?
Yes, Your Honor, we found out about it, or I really found out about it along with the defense yesterday.
And I think the scope of what we needed to both see was greater than what either one of us anticipated. So I would agree with that.
All right. So how much time are you all asking for? I want to make sure that both parties have the information that they're looking for.
So Judge, right now, we sent an email out on this case to our investigator. The jail said that they would compile the list of visits concerning Mr. Gonzalez-Lopez. And I believe those are ready to be picked up. We just haven't had the ability really right today to go do that. So I'm assuming that those are going to be uploaded relatively shortly, and we can provide that to defense via e-discovery.
All right. And the visits, I'm assuming, were done by video?
Yes, Judge, that's my understanding.
And nobody knows how long those visits took place, correct?
No, Judge.
Do we have any idea or approximation of how many videos?
So in speaking to the detective indicated to us that there was about 3 or 4 visits concerning Mr. Gonzalez-Lopez. He said that they all varied in length. I don't think he ever gave a specific time as to how long each video or visit was. Did he, Kathy?
No, and I think that there were some other visits that Hank had requested too. So I think the total is going to actually be a little bit more than that. But I would think that they were probably, I mean, generally speaking, the visitations are about 45 minutes to an hour generally. My only concern is that I'm in the middle of preparing for a murder case that's, I think.
No, I will get, yes.
So.
Well, I can tell both parties.
Time to look at everything.
No, I'm going to give you all both time to look over everything and also schedule a trial date if that's what's decided. And I'm assuming the visitations, and this is assumption on my part, took place in Spanish.
Yes.
That's the assumption.
And so maybe there's a transcript needed, maybe not. And then there's the other issue of if he was presenting himself as an attorney, is that attorney-client privilege, even though he's not an attorney? So I think those are issues.
That's a definite no.
Yes. Yeah, no, he's not an attorney.
I would say that there is, I certainly don't think there's any privilege that would keep me from looking at things.
No. That what I mean is if, and this is just me asking a question, if somebody has case law on it because new things pop up, the question is going to be, what did your client say? And whether or not this person was holding himself out as an attorney and he assumed that's his attorney, whether or not that equals attorney-client privilege. That I don't know. So people may want to start doing some research on that.
Yes, Judge.
Because I would think that if you're speaking to your attorney, you would probably tell them things. Not saying that it would be anything incriminating. We just don't know.
Well, I just want to make sure that my client's rights are protected to the absolute fullest extent of the law, as I know everybody here is interested in doing, because that is our ethical duty.
Yeah.
So I think just giving us some time to look through those things to see if they're pertinent, and we can address it together once we all have a chance to look at everything.
All right. Well, off the record for a moment. This is what I think. And this is just me looking ahead. Depending on if this person presented himself as an attorney, then it may be items that the DA's office should not be looking at or looking to transcribe. So I would think it will probably be prudent on the state's part and everybody's part is if the items are obtained for the state not to look at them until it's determined if this person was saying, I'm your attorney. And then everybody look into case law on what makes attorney-client privilege. If you're dealing with someone who's not actually an attorney, and you assume that they're attorney, does that still give you attorney-client privilege? And it may be something that the state should not review.
If you think that that would be the best way, just to avoid any further complications, potentially, I would be more than happy to go ahead and, well, and I think the same goes for Mr. Leal with his client. We could review those, and if we do think that there's an issue, we could certainly bring that to the attention of the court.
All right, we're
for
back
your
on,
review.
okay, all right, we're back on the record. These are my thoughts. If you all obtain all the information, and if both parties want to put it under seal, I'll review it. Of course, I'll have to have an interpreter. And if I review it, and if it appears that that person is presenting themselves as an attorney and as his attorney, and then I will let you all know, this is what has happened. This person has presented himself as his attorney, then everybody can file whatever motions they want to file as to whether or not the state should have privy to that.
I would feel much more comfortable with it going to you, even if it has to be transcribed or translated, and then you making that call, because I think that puts the responsibility, I guess,
Yeah.
that heavy burden where it needs to be as far as making any calls on who gets what.
All right. And so just so everyone know, the part that I'm going to listen to is whether or not this person meets with your client by video or in person and presents himself as his legal attorney.
Yes, Judge.
And then once that's determined, I will let you all know. He says he's his legal attorney. Then you all will do research. I will do research on whether or not that's attorney-client privilege, even though that person, we're assuming, is not an attorney.
Yes.
And Judge, what I was gonna do, because I did request the visits for Mr. Leal's client as well. I took that step. What I was gonna do is see if our investigator can go through sort of the same process that he did on this case, because my understanding is that they're supposed to be put on a flash drive,
Yes.
and then he's just gonna pick them up. So I'm gonna see, I emailed about Mr. Leal's client maybe about an hour and a half ago. So it might just be easier
Alright.
just to say, hey, can you just do the same thing?
All right. And Mr. Leal, could you state your name for the record, please?
Rafael Leal.
And Mr. Leal, you're representing
For
Caroline
Juan Velasquez.
and cause number 2022 CR 10958B. Is that correct?
Correct.
And he's also in custody and he's in the courtroom.
Yes, Your Honor.
So it's the court's understanding then that neither defense attorneys would have an objection to the state not reviewing the videos that this person may have had with your clients, the video visitation on video or in person, that I will receive the evidence that they have. I will have an interpreter and it transcribed to see whether or not this person presented himself as the attorney of your client, Ms. Compton, and your client, Mr. Leal. And once that's determined, then you all will have to do your research. I will do my research, and it'll become a question of whether or not attorney-client privilege was established. And of course, if it was, then the state would not be entitled to this information. It would just go to the attorneys. Is there any objection to that from either defense attorney?
No objection from my side, Judge. I only have a question. Has those videos been reviewed by anybody, any detective who understands the Spanish language, or anybody else in the district attorney's office? That would be my only question. Perhaps they have already reviewed those things.
May
At
I
this
speak
point.
to that, Judge?
Yes.
So my understanding is that the assigned detective to the case involving Mr. Berrocal attempted to review. However, he does not consider himself to be proficient in Spanish. He speaks some Spanish. So he communicated to both Daniel and myself that he was not able to say with any certainty what the conversations
All right.
contain.
So State, I understand that there may potentially be charges against this person for perhaps presenting himself as an attorney. But if you could let the detective know that they're not to review those tapes as they relate to this case. Any detective who's involved in this case or officer who is involved in the case out of this court is not to review those.
Okay.
That it will be sent to me and I will review those and do in camera.
Does that include members of the district attorney's office?
Oh, you were not here for that discussion. The district attorney's office is not going to be reviewing that. I will review it. And if either party says, you're my attorney, or this person presents himself or has presented himself as the attorney for your client or Ms. Compton's client, that's all I'm going to listen to. And then I will let you all know that he presented himself as an attorney. Then the next question is going to be whether that's enough to establish attorney-client privilege when in fact this person is alleged not to be an attorney.
And if it turns out that that you don't find anything like that, then I'm assuming at that point it'll be released to everyone.
Yes.
Okay, sounds good to me.
And Judge, I found the detective, his email in my address book. I was just gonna send him an email.
All right,
Pretty
thank
much
you.
All of us.
Yes.
including you, Judge.
Thank you. So, Mr. Leal, that's the court's proposal. Ms. Compton is in agreement with that. Are you in agreement with that?
Yes, Your Honor.
All right, so my understanding is that they already have the videos. So let me see what date we can bring this back. And State, when do you think you'll be able to have the videos to the court?
That I don't know, Judge. I think it's more just scheduling with our investigator to go pick them up.
All right. So what I'm going to do then is I'm going to recall this case. I know that spring break is, I guess, the week of March 11th or the week of March 18th. Am I correct? Who has school-age children? All right. So we're going to recall this for March 4th. And on that date, that State March 4th, is that enough time for it to be given to me? All right, so March 4th, just so everybody is clear, the only thing is going to happen on that date is you all going to come in at 9 a.m. and we're going to make sure that I have the videos and have whatever documentation of the visitations that happen at the jail. All right?
Yes, Your Honor.
Is there anything else from either side?
Not from my side, Judge.
Not at this point, Your Honor, no. Thank you.
All right, and Mr. Leal, you're fluent in Spanish?
Fully, yes.
All right, if you will please let your client know, because we didn't have two headphones for each client.
I'll let him know, Judge.
All right, is there anything else that we need to take up?
No, thank you, Your Honor.
Dana?
Mr. Reyna, we had requested some judgments from past hearings he's had and held, and we were provided those today. One of them, and I had received already one. I discussed that with my client, and he kind of doesn't like the way I'm approaching everything and doesn't like the way or he feels that I'm not representing him accurately.
Mr. Rayner, come on down.
So we might want to talk to him because he's asked me to get off the case. And I told him that's something you have to discuss with the judge. And for the record, we have been relayed an offer to my client.
All right, so Mr. Rayner. Are you Mr. Rayner?
Yes, Miss.
All right, so it appears to the court that you do not want to come dressed for trial when you're supposed to be dressed for trial.
Well, believe it or not, Miss Boyd, I wasn't aware of this trial in the first place. And then
No, because
second,
here's the thing. Firstly, when a deputy at the jail tells you you're supposed to be dressed for trial, you're dressed for trial.
I wasn't
And when
told
your
to be
time,
dressed.
you were told before and you didn't do it. And guess what? If you ever come back to this court where a deputy at the jail has told you to dress for trial and you're not dressed, you know what's going to end up happening? You're going to be going to trial in that red jumpsuit. And you know why you're going to be going to trial in that red jumpsuit? Because it's going to have been your choice. I am not having you come back to this court again where you're pretending as though nobody told you you had a jury trial. The other thing, you're saying that your attorney is telling me that you want another attorney?
That's correct.
All right, then you need to hire one. Do you understand?
I don't have any support issues. Support at all as we speak right now at the moment.
What
And
support for
possibly
what?
It's ordinary to hire an attorney.
Oh, well, then this is your attorney. This is what I've discovered, and I've told many people this before. This is what ends up happening. When you, as a defense attorney, are placed to represent somebody and you've been appointed to represent them, number one, there are certain qualifications that you must have. This is a third-degree felony. It may be bumped up to a second-degree felony based upon what's in the indictment. This attorney would not have been appointed to your case if he didn't have the qualifications to be on this case. I don't allow attorney shopping in this court. Whoever comes up on the wheel, that's who your attorney is. The state will tender an offer to your attorney because I require the state to tender an offer. State can make an offer and say, we're offering 20 years. The state can say they're offering the maximum. Guess what? Your attorney has absolutely really no control over what the state is offering.
So what's
Even if your attorney were to go to the state and say, well, these are the weaknesses in your case, and this is what my client is willing to accept, the state can still say, I am not going to offer your client what he wants. The only thing I will offer you is A, B, or C. And your attorney ethically is obligated to tender that offer to you. Now, you can accept it or not. That's completely up to you. There are certain rights you have when you're charged with the offense. One of them is whether or not you will accept an offer or not, and whether or not you will testify at trial, and what plea you will enter. Do you understand? So you're not getting another attorney. If you want to hire one, you are more than welcome to hire one. So this is your attorney. Next question.
Why does my case carry at least prison time and not probation?
Here's the
or
thing.
anything?
You will have to speak to your attorney. What I can tell you is there are certain cases, number one, that you're not eligible for probation. There are certain cases that if you go to a jury trial and if you are found guilty, you're not eligible for probation. There are some cases that if you go to jury trial, maybe you're eligible for probation from a court. But I cannot tell you whether or not, just based upon looking at your case, which would be the indictment for me, whether you're eligible or not. What I can tell you, though, usually if you have a repeater count and you go to a jury trial, you're not eligible for probation. So you need to speak to your attorney about that. And I'm sure your attorney will tell you whether or not you're eligible. Think of criminal history this way. If you have somebody that you loan money to, right? Let's say somebody comes to you and they say, can you loan me $50 and I'll pay you back next week? And you say, yes, I will loan you the $50. What are you going to use it for? Oh, I got to pay my electric bill, which that would be a good electric bill these days. And that person gets the $50 and they don't pay you back. And you said you pay me back on this day. You're not paying me back. That person comes to you for a second time and said, look, I'm in dire straits. They're about to cut off my electric bill. I need $60. And you tell them, you know what? I gave you $50 just last week and you never paid it back. And they're like, I know, I'm so sorry for doing that, but I promise you this time I will pay it back and I really need the $60. So you loan them $60 and they don't pay it back. And then they come to you for a third time. You may say, I'm not going to loan you any money. I don't care what your problems is because I've loaned it to you 2 times before and you haven't paid it back. Sometimes people view criminal history that way. And when I was a prosecutor, sometimes people would view criminal history that way. They would say, you know what? I gave you probation before, you didn't do well on it, and you pick up another case. I gave you probation the second time, you didn't do well on it, and you pick up another case. So maybe that could be a reason why people make offers that they make. But what I want you to take away from this conversation is this attorney, according to the will, is qualified to handle the type of case that you're charged with. And I would tell you one of the qualifications they must have, and Mr. Gomez, correct me if I'm wrong, he has to have tried cases before, and he has to have tried felony cases before. You can't just have tried misdemeanor cases and then come to felony court and say, oh, I'm qualified. That's not how it works. So he's tried the necessary cases. And if you are upset by the offer that he is tendering to you, no, that is the offer that is the state has made. And in this court, I require everybody to treat each other with kindness. So I guarantee you, when the state made him that offer, the state wasn't mean. The state just says, this is the offer I'm making. And I expect you to treat your attorney with respect. I'm sure your attorney will treat you with respect. But again, if you want a different attorney, you need to retain an attorney. So that means you need to go out and hire an attorney. And if you don't have the money to hire an attorney, then this is your attorney. Do you understand? The other thing I want you, that's either yes or no.
Yes, miss.
The other thing I need you to understand, and again, we're not doing this anymore. If you are at the jail and they're ordering you dressed for court, that's me ordering you dressed for court because you're up for trial. And I will not have any qualms whatsoever with you going to trial dressed in that red uniform. And you and I both know that red uniform has several meanings attached to it, just the way the orange ones does and the blue ones does. The blue one for females, orange, just regular inmates. The red, gang member, age issue, in admin segregation. Yellow with stripes, pregnant, or just yellow, pregnant. Tan or grayish looking color, trustees. So if you want to come to trial dressed in red, that is completely up to you. Do you understand?
Yes, miss.
Do we understand each other?
Yes, miss.
Do you understand the offer that the state has made to you? That's either yes or no.
Yes.
Do you need to confer with your counsel anymore on the offer that the state has made to you? And if you would like to make a counter offer, I'm sure if you would tell your attorney, well, I want to accept this, but this is what I will accept. That's what's called a counter offer. But what that means is you're telling the state, I'm not accepting your offer. I will only accept this. So that means that you're rejecting the state's offer and it may or may not appear for you again. Do you understand?
Yes, miss.
And I'm sure this attorney will be able to tell you what your range of punishment is in this type of case. I cannot tell you that because I don't know the facts of your case. The only thing I have before me is an indictment. You understand?
Yes, miss.
Do you need to speak with your attorney some more? Do you need to see what evidence the state is saying they have?
No, miss.
Have you already seen that?
Not quite yet, but yes, I have.
Mr. Gomez, will you let him see that since we're all here?
I could confer with him again.
All right, so your attorney is going to confer with you and the state will let him see their file so you can see their file and see what they have, okay? All right, thank you. 2019 CR 11647, State of Texas versus Jamal Trayvon Coleman. Can our parties announce for the record for the state?
Travis Banks, State of Texas.
Defense?
Monica Corolla for defense.
And are you Jamal Coleman?
Yes, ma'am.
Are you the same Jamal Coleman who was placed on deferred education in 2019 CR 11674 for the offense of aggravated assault with a deadly weapon on November 5th, 2020 for a period of 8 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 2 on or about the 7th day of June 2023 in Bexar County, Texas. The defendant, Jamal Trayvon Coleman, did then and there fail to submit to a drug test in violation of condition number 2.
How do you plead to that? True or not true?
True. The state will waive and abandon the other allegations.
All right, did you understand by pleading true to violation of condition number 2, court could find it true, grant the motion, find you guilty and sentence you up to 20 years in prison and up to $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, ma'am.
Court will find violation of condition number 2 true. Is there an agreement?
Yes, Your Honor, the agreement is, and should Your Honor choose to follow it, is to deny the motion and to alter and amend his conditions of probation to include the ISF dual track, and for him to complete the dual track and continue on probation.
All right, is that the agreement?
It is, Judge.
All right, Mr. Coleman, raise your right hand for me, please. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Jamal Trevon Coleman.
All right, Mr. Coleman, do you want to go to prison?
I'm not allowed enough.
Then why do you keep coming before me with violations?
I have an issue with drugs.
I mean, I know that, but I've sent you to different places and you're just not doing well. And so I don't know if I can help you or not. I don't know if you want the help. I can put people in whatever class that's available for you. If you have a drug problem, I can put you in a class for drug issues. But if you go there and you sit there and you internalize, but the first thing some problem comes before you, your answer is, oh, let me use drugs.
May I speak?
Yes.
I didn't get a chance to, I didn't really complete the first program, the safe P that you put me in.
Mhm.
I don't know if you remember, but I had a colostomy bag.
Yes, I do remember you.
So I got my colostomy bag removed,
Mhm.
but I didn't stay at the safe P facility. They took me to an infirmary unit. And so I've kind of missed the whole entire program. I think I was only in the program for about 2 months,
Mhm.
if that. So I didn't really get a chance to be in the program.
So you had a colostomy bag and again, you're using drugs.
Yes, ma'am.
That doesn't work well for anybody's health. And I will tell you, I have some friends who previously were addicted to drugs and now they've been clean and sober for about 30 years. And they will all tell me, Stephanie, I can no longer abuse my body because I abused it so much. So guess what? They don't do ice cream. They don't do any of that. They're always working out, fruits, vegetables, their proteins. That's it, because they put their body through the ringer. And how old are you?
I'm 26.
You putting your body through the ringer. And I will tell you, meth not only affects the mental health part of it, but it affects your heart, it affects your liver, it affects everything else. You understand?
Yes, ma'am.
Probation. I'm sorry, do you have any gang affiliation?
I did when I was younger, not currently.
And what was that?
Blood.
He's saying that he's not a gang member anymore. I don't think felony drug court will accept him because I had put on here at one time, refer back to felony drug court, and they said no. Am I correct?
That is correct. I believe they will not accept him back.
And will ISF accept him with his gang affiliation?
We'll have to do an evaluation.
All right. I'll deny the motion. Alter and amend conditions to include ISF dual track. If he's not accepted by ISF, then it's going to be safety.
Yes, ma'am.
Is there anything else you need from the court?
No, ma'am.
Am I going to see you back again here for this nonsense?
Got it. No, ma'am.
Do you have the tools you need to not use?
Yes, ma'am.
All right. Do you have a support system at home?
Yes, ma'am.
Who's your support system?
Grandmother, my mother, my father, my elderly grandparents.
All right. So you need to stop disappointing them, because I'm sure each time you use, your mom's heart breaks, your grandparents' hearts break, your dad heart probably breaks. You understand?
Yes, ma'am.
Nobody wants to, because you never know if the last time you use is the last time you use. Nobody wants to be called to have to identify your body because you're the person on the news who's on the street, and they'll just say drug overdose, and then they'll go on to the next person. You understand?
Yes, ma'am.
All right. Good luck to you.
Thank you.
Yeah.
Please subscribe to help the channel.
Outcome. The first defendant is warned. Trial proceeds with current counsel, and court decorum is non-negotiable. In the second case, the judge denies the motion to revoke and tightens probation with an ISF dual-track plan. Follow for more courtroom breakdowns.
23 CR 2675, State of Texas versus Adam Hanlon. Can I have parties announced for the record for the state?
Travis Banks in the state of Texas.
Defense.
Angela Blake.
Are you Mr. Hanlon? Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Hanlon, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, the state moves to proceed on the lesser included assault, bodily injury, family, class A.
Any objection?
No objection.
So the complainant in this case, is this complainant his wife or is this the daughter? Who is this complainant in relation to him?
Girlfriend.
All right. So what I can tell you all, this is not a plea agreement I'm not going to accept. Is the complainant aware of this plea agreement?
Plaintiff is uncooperative, so we have not communicated it to her since she told us she would not cooperate in this case.
All right. So is this 111 days supposed to be a judgment satisfied?
Yes, Judge.
All right. So I'm not inclined to give him 111 days judgment satisfied on assaulting.
There are circumstances that he does have a partial defense to the case, Your Honor, but he is not pursuing it. There was the complaining witness did use a hammer on him during this incident,
Mhm.
and so he had injuries as well.
All right. I'll agree to 160 days based upon what you're telling me. I think that's more appropriate than 111 days. So if y'all want to do that, you can. If not, then it'll be set for trial. But I'm not going to give him a judgment satisfied.
We'll accept that, Your Honor.
All right. Do y'all want to?
I can mean.
Right. All right. I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes.
Did you understand the state is proceeding on the lesser included offense of assault, bodily injury, married cohabitation? That's a class A misdemeanor. The range of punishment is anywhere from a $4,000 fine and up to 1 year in the Bexar County Jail. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you enter the plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to confront any witnesses the state would call and the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case?
That's fine.
Counsel voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find the defendant guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We just ask the court follow the plea bargain, Your Honor.
All right. Are you the father of the unborn child?
You don't know yet.
Oh, well, that relationship is not going well if you don't know. All right. So this is what the court is going to do. The court is going to sentence you to 160 days in the Bexar County Jail, give you credit for any time served. There's a $500 fine, time and money to run concurrent. There's an affirmative finding of family violence. There's to be no contact with Digna, D-I-G-N-A, Maria Narvaez, N-E-V-A-R-E-Z, Romero, outside of court proceedings. So if you're going to court to prove paternity or some other reason for going to court, then yes, but otherwise your relationship is over. Do you understand?
Yes, ma'am.
Showing you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? Because there's an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. You're going to have to make better decisions. Right? And if you cannot drink responsibly and it causes you to have criminal cases, you should not be drinking. And there's nothing missing by drinking. You know what is a great drink? Sprite. And if you add a touch of lime to it, it's so refreshing. Coca-Cola, add some lemon to it. So refreshing. That's what I do. And Cappy's has a great drink that I've tried to duplicate and I can't. It's cranberry juice with lemonade in it. And the lemonade surrounds the cranberry, but it tastes so great. So there are other things, other drinks to enjoy other than alcohol.
I understand that.
All right, sweet tea, sometimes people put too much sugar in it, but oh well. Good luck to you, okay?
Thank you.
Thanks.
You're welcome. 2018 CR 9274W, State of Texas versus Javier Zepeda. Can I have parties announced for the record for the state?
Travis Banks in the state of Texas.
Defense?
Arnulfo Ortiz.
And are you Mr. Javier Zepeda III?
Yes, Your Honor.
I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision,
Yes,
and state's motion to supplement pending motion to enter adjudication of guilt and revoke community supervision. Did you review those documents with your attorney? Did you understand them?
Yes, ma'am.
Are you the same Javier Zepeda III who was placed on deferred adjudication in 2018 CR 9274W for the offense of assault family second offense on September 5th, 2018 for a period of 3 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 5 in Bexar County, Texas, the defendant Javier Zepeda III did then and there fail to report to the supervision officer in person for the months of May 2020, June 2020, and July 2020 in violation of condition number 5.
How do you plead to that? True or not true?
True. The state will waive and abandon the other allegations in the motion.
All right, any objections?
No objection.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, ma'am.
Court would find violation of condition number 5 true. Is there an agreement?
Your Honor, there's not exactly an agreement. The state is recommending that the defendant be revoked and sentenced to 5 years, but I believe defense has their own request for the court.
All right, defense, what are you requesting?
My client, his family, his employer, and I are requesting that he be allowed to do inpatient, to be allowed an electronic monitoring device, and to continue on probation. We would not be opposed to extending them as long as it's physically possible. If we have witnesses, we have some testimony we think the court will find relevant.
All right, probation?
Your Honor, this case expired in 2021. So an extension of probation at this time would not be an option.
Yes.
I understand, Your Honor. We have in the courtroom today, Mr. Joe Ricky Naranjo, his employer.
Mhm.
We have his mother, and we have his father. The problem here is that this man has been a heroin addict, Your Honor, and he's trying to bring that under control. Even while he had absconded, he has been going to get methadone. He's been going to the methadone clinic. And his mother's a witness to the fact that she takes him every day to the methadone clinic. And the father is here to testify that he himself has been on methadone for 10 years and is supporting his family and has a full-time job, is a supervisor, and he's a methadone user, and that's how he fights his cringes. And this young man is taking methadone.
So this is the question. Here's the thing. These are the answers I need to make an appropriate decision in this case. Now, even though I cannot extend you, I can find you guilty. I can give you regular probation, but there are questions that I have that need to be answered.
Yes, ma'am.
And those questions are going to be, where has he been? And what has he done on probation?
Tell the court what program.
Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record, please.
Javier Cepeda III.
All right, off the record for a moment. Could I see the attorneys on, so where have you been?
I've been working, ma'am, and Spain with a family member. I actually have 3 jobs.
All right, so you were in felony drug court
Yes, ma'am.
and you didn't do well. Felony drug court is a good program. And what I have is that you were sent to felony drug court. You were placed in ISF. You were returned back to felony drug court. And by the end of April 2020, you were testing positive for opiates and marijuana. You continued to use drugs. You were not in compliance with felony drug court outpatient treatment. And then you stopped reporting. And then you contacted your case manager. And I'm aware of all the parties in felony drug court because I used to be an attorney in felony drug court.
Yes, ma'am. I'm aware of that.
You contacted her in July 2020. You requested help.
Yes, ma'am.
So they arranged for you to go to detox, go to Center for Healthcare Services, and then be transitioned to lifetime residential treatment upon detox.
Yes, ma'am.
You entered detox, then you left detox.
Yes, ma'am.
Then a warrant was issued for you, and then you stopped communicating with felony drug court.
Yes, ma'am. I got scared.
Well, no,
I had a kid on the way, so I made a
don't
stupid
use that
choice.
fear thing
No.
with me. And let me just tell you why I don't use the fear thing with me. Because I'm reading this and felony drug court, I know how they work. When people relapse, they don't immediately cut you off.
Yes, ma'am.
And that's evidenced by the report that I'm reading, that they gave you chance after chance. They sent you to detox. So you leaving detox, don't try to use your child as an excuse. I had a baby on the way, because that wasn't the reason why you left detox. You left detox because it got hard and you wanted to use, and you're continuing to use. So do not use your child as an excuse for why you are not clean and sober.
Yes, ma'am.
So I don't believe there's anything that I can do for you because felony drug court has tried it all. You absconded from felony drug court and they still accepted you back after you absconded. They were giving you help and then you absconded again. And I understand that there comes a point in time in people's lives where they're like, okay, now I'm ready to do it. But at some point in time, the court can't continue working with people who don't want to be worked with. And your problem is your chances to be worked with have elapsed. There is no chance to be worked with. You're going to have to do it on your own.
When he wasn't reporting, he was taking methadone to make sure he did not go down the spiral. He was trying, and his family's here to say that they worked with him with that.
But all he had to do was pick up the phone and call felony drug court. Have you read? I'm going to read this to you. You've been an absconder for almost 3 years. As an amended condition of probation due to a motion to revoke, Mr. Zepeda was placed in the felony drug court program on January 24th, 2019. That was me who did it. It says, Mr. Zepeda struggled to anchor in with outpatient treatment and admitted a drug relapse. And I can tell you, when I placed you there in 2019, I had to call them and say, please accept him. I know y'all are booked and don't have room for him, but he's on the edge. Can you please accept him? And they did. And then it says, as a graduated sanction, they placed you in the Bexar County ISF program on October 30th, 2019, and you completed it on March 3rd, 2020. You returned to the felony drug program, and by the end of April 2020, you were testing positive for opiates and marijuana. Mr. Zepeda steadily declined into further drug use and non-compliance with the felony drug court program rules and outpatient treatment. Mr. Zepeda fell off the grid and stopped reporting for the months of May and June of 2020. Mr. Zepeda contacted his felony drug court case manager in July 2020 and requested help to regain sobriety. She arranged for you. They didn't say, oh, we're going to revoke you. We're going to send you back to the 187. She said, we're going to get you into detox. So they sent you to the Center for Healthcare Services. And then they said, after that, after detox, you're going to go into lifetime residential treatment. And you entered detox on January 7th, 2020. You stayed there for 2 days. They said a couple of days. In my mind, that means 2. And you left. A judge's warrant was issued for you on July 13th, which tells me when you left on July 7th, they still gave you chances to get back in line. And then it says you stopped communicating with all felony drug court team members and you remained a fugitive. And what I can tell you in felony drug court, there are attorneys there who always say, let's try to get them back in compliance. Let's try to find them. They have officers who are trying to get you back in compliance, caseworkers, the counselors, everybody's probably on your phone calling you, calling your family. And you just left. I can't do anything for you. You're going to have to get the treatment on your own. I'm going to find you guilty. The only issue is how much time. The state is asking for 5 defense. What are you requesting?
3 would be fair.
Okay. All right. This is what the court is going to do. The court is going to find you guilty. The court is going to sentence you to 3 years in the prison. Give you credit for any time served. I'm going to ask for the therapeutic community. Therapeutic community does not increase your time in custody, but if you're serious about getting clean and sober, you need to request that. I can't order it. There's a $500 fine, time and money to run concurrent. There's an affirmative finding of family violence. There's to be no contact with Carla Chavez.
Yes, ma'am.
All right, and state, will you let Ms. Chavez know that he's been revoked and he's going to prison?
Yes, ma'am.
Okay. Just show you what's entitled trial court. You probably want to go around. Okay. To show you what's entitled trial court certification of defendants' rights to appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, this is not a plea bargain agreement. You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Do you understand?
Yes, ma'am.
All right, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
And also because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, we can go off the record. If you have a child, you need to do better. You have family here who's supporting you, you need to do better.
Yes, ma'am.
You need to pick up the phone because I know felony drug court gave you the tools you need in order to stay clean and sober. It's just a matter of you using them. All right?
Yes, ma'am.
All right, good luck to you.
Thank you, Your Honor.
You're welcome.
Please subscribe to help the channel.
Outcome. In Case 1, the judge accepts a plea only at 160 days, adds family violence findings, and orders no contact. In Case 2, deferred adjudication is revoked. 3 years prison, plus therapeutic community request. Follow for more courtroom breakdowns.